Excuse me. And as I mentioned, this training is sponsored by the Workforce Development Board of Alameda County. And today we are so pleased to have Darlene Hawkins, who is the Business Services Manager, who's here to share more about the resources available to employers like yourself. Good afternoon, Darlene. How are you?
Good. Thank you, Anna. Thank you to the California Employers Association for hosting this webinar. As you see on the screen here is the hotline for employers. Many of you may have already used this hotline. Along with that, the Alameda County Workforce Development Board serves all of Alameda County businesses. If you have training needs or if you would be interested in the incumbent worker customized training, on the job training, or would like to formalize an apprenticeship or have any questions related to any of the workforce programs that we have to offer, you are welcome to reach out to me and visit our website, Alameda County Workforce Development Board, acwdb.org. Thank you.
Awesome. Thank you, Darlene, and your whole team for everything that you do for employers in your county. So now I'd love to introduce our trainer today. We have Eli Nunez, one of our HR directors. So you are in great hands. And Eli, it's all yours.
Thank you very much, Anna. Thank you, Darlene, and thank you to Alameda County Workforce Development Board. Again, I'd like to remind you if you have any questions about any kind of HR topic or about this presentation, feel free to call that 800 number. There's somebody there from Monday through Friday, 8 to 5, ready to answer your call. Or even if you just had something you want to talk through, maybe you have a situation that you're not sure how to handle or something you haven't seen before, give us a call. We'd love to talk it through with you and come up with the right answer. A little bit more about us. We are the California Employers Association, and we strive to bring everybody peace of mind. Anyone that interacts with us, whether it's on the phone and training such as this, whatever it is, we try to give you the right information so you can make the right decisions. We know HR is very complicated, especially in California, so we do what we can to keep you up to date and to help you out with that part of your business. Now, having said that, we do provide a lot of advice and a lot of information, but one thing we do not provide is legal advice. We are not lawyers, and I'm definitely not a lawyer. And even though we have people on our team with legal experience, we do not give legal advice. We always recommend, if you have any questions of legal nature, consult that with your attorney. We'll talk about laws, we'll talk about guidelines, we'll talk about what the state requires, but again, we won't give legal advice. Same with this presentation. This is for informational or educational purposes only. So, we hope you get some good information out of it. And if you have any questions of legal nature, again, we recommend that you consult your attorney. So let's jump right into it. Some of the topics we'll be covering today about what to do when ICE shows up at your business. So we'll talk about why we're seeing increased enforcement right now, how to prepare for a workplace raid or a workplace visit. Then we'll talk a lot about I-9 forms, how to inspect them, what the requirements are in California, and how to audit those forms. As you know, that's usually the first line of defense when you're hiring new employees, making sure that they are authorized to work in the United States and everything is in line. So having those I-9 forms in order can really go a long way in helping you repel, if you will, any additional action from ICE after they want to take a look at your I-9 order. So we'll talk about best practices there. But let's start from the beginning, why we are seeing increased ICE activity right now. And this really goes back, honestly goes back to the first time Donald Trump was president, but it really came full force around this time, starting with an executive order signed on January 20th, which basically instructed the government to hire more ICE agents. And after this, the administration set a goal, very publicized goal, that they're looking to make 3,000 arrests per day. This was done by the president's chief of staff, Stephen Miller, where he was demanding that from ICE, USCIS, Customs and Border Patrol, et cetera, et cetera. And on top of that, going back to the I-9 inspections that I mentioned, agents are being asked to have a certain number of I-9 inspections per week. So this is something that we could see rolling out and affecting more and more employers. And realistically, these actions, they do seem drastic. These are nothing new. This isn't anything that we haven't seen before. Going back to the 1930s during the Great Depression, you had the Mexican repatriation action going on when anywhere between 300,000 to 2 million people were deported or repatriated, if you will, to Mexico, including 40 to 60% of them, which are estimated to have been U.S. citizens that were removed from the United States and repatriated to Mexico. And we saw similar action again in the mid 50s during, I believe it was Eisenhower's administration. This was called Operation Wetback, where the INS claims to have deported more than 1 million people back to Mexico. Actual figures put it around more, a quarter million or so, but again, the INS likes to tout that $1 million number. And going back even further, you had things going on like the Chinese Exclusion Act, actions against Russian immigrants, against Irish immigrants, that sort of thing. So it's one of those things that just kind of keeps repeating itself. And, we're seeing it really come to a head right now. On top of that, with the recent signing of the One Big Beautiful Bill Act, or OBA as we call it, it's passed this last July 4th, and it earmarked about 170 billion for immigration and border enforcement related funding. So, top of this, about 30 million of that's going towards ICE, or Immigration Customs Enforcement. And honestly, if you're assigning that or allocating that type of money to a goal or an activity, you can be pretty sure that there's going to be results demanded. So we're going to see, a push to get those deportation numbers up and see a more public action to show that where that money is going. We've seen other things going on, like the offer of student loan forgiveness and signing bonuses for new ICE agents. And, you know, what all this means is that, actions and arrests have gone up. I mean, according to the Department of Homeland Security, which oversees ICE, they are estimating that ICE arrests have increased by 627% in 2025. So more than 6 times as many arrests as there were a year ago have taken place. And again, that number just keeps climbing and climbing now that there's more money allocated to it and more publicized actions going on. And maybe asking yourself, well, this is terrible news, but what does that mean to me as an employer? Well, there could be some drastic effects for employers, especially those found not to be in compliance with immigration guidelines, laws, enforcements, whatever you want to call it. And there are penalties for hiring, recruiting, or referring unauthorized immigrants for employment, or even if you employ somebody and you continue to employ them after you learn that they're unauthorized. Now, civil penalties can go anywhere from $700 up to $28,000 per individual if you're found to be doing it purposely or a repeat offender, if you will. There's also criminal penalties involved if it's found that you have a pattern of hiring unauthorized immigrants to work or continuing to hire them, up to $3,000 and or 6 months imprisonment per violation. So if you have multiple employees that are unauthorized to work in the United States and you know this and you continue to employ them, you could get the book thrown at you, obviously, right? $3,000 and 6 months per violation. That can add up really quickly. On top of that, there are penalties and fines for paperwork errors. In other words, if there's minor mistakes on your I-9 forms or that sort of thing, those can also come with fines and penalties themselves. Now, having said that, I'd like to ask, we had a poll earlier, so I will ask this one as well. Do you feel that your organization is prepared for an ICE raid or for a visit from ICE? Let me go and launch this poll and let me know what you think. How do you feel? Do you feel you're prepared for it? Um, are you somewhat prepared or you're sure that you're not? We'll leave this up for a minute, see what you think, and then we'll show you what some other surveys have found from other employers of what they believe. So let me leave this up for a few seconds, if you will, and go ahead and just click your option. Do you feel that you are prepared? Yes, kind of prepared, or no? So give you a minute here while I get a drink of water. And we'll close that down. Looks like we got a bit of a mixed bag there. Some people feel they're prepared, some people are not sure. And you know what? SHRM did a survey recently and found that more than half of HR professionals surveyed felt that they were not prepared, that their organization is not prepared for an ICE raid. Many different reasons for this, of course. Some maybe know that their practices aren't as tightened up as they could be. Others, it could just be that fear of the unknown, right? Maybe they've never gone through an ICE visit, an ICE raid, or an I-9 audit, so they don't know what to expect, so they don't know if they're prepared or not. But 52% is a pretty drastically high number and kind of goes in line with what we see today. So again, if you don't feel you're prepared, you're not alone, and that's why we're here for, right? So let's talk about what happens if there is a raid or visit at your workplace. And what are your rights as employers? So, thing to be aware of is whenever there's a visit or a raid from ICE, um, they don't always have to give you advance notice, and typically, a lot of times they don't. They'll just show up at your door. It could be anything from, one or two agents coming by with some documentations or to ask some questions, or you could see a full force of different agencies coming to visit you. And if you've seen the news, you see that these can be intimidating sometimes. You have people showing up with tactical gear, face coverings, that sort of thing. So obviously it could be unnerving and it could be a disruption for your business. And thing to keep in mind is, you do have some rights, you can deny some access. However, law enforcement agencies can access any public area of your business without a court order or warrant. So what that means is if your work area has like a lobby, a parking lot, if you're a restaurant, any place that's accessible to patrons or customers, that is also accessible to law enforcement agencies. That's not the case if you have any private areas, right? Any employee only areas, and we'll talk about what that looks like and how you can use that in your favor or your advantage. Now, when you do get a visit from Border Patrol or immigration enforcement agencies, ICE, whatever it is, there could be a couple different things that they're there for. The first one is could be to collect documentation or evidence, you know, a fishing expedition, if you will. They're there to see what they can see, right? Otherwise, they could be there to look for a specific person. If there's someone with a removal order, they got one that they work at your place of business, they could be there to try to get them, catch them, whatever it is. Or it could be just to verify that all your documentation is in order. In other words, if you have anybody that works with you that's under an H-1B or H-2V or H-2A visa, they have, they're aware of that because those have to go through USCIS. So they could be there to audit that information, make sure everything's up to date, make sure the person's still working there, make sure you're doing everything as you should. And again, just a reminder, these visits can be with or without notice. In other words, you get a call or a letter ahead of time letting you know you're going to be audited, or they could just show up at your door. And again, this could be different agencies that are conducting these visits. The one we hear about the most is ICE, Immigration and Customs Enforcement. It could also be, they could show up wearing badges or wearing vests that say Department of Homeland Security, which is a little further up the ladder there. Customs and Border Protection, or USCIS, the U.S. Citizenship and Immigration Services, or even the Border Patrol. And you're thinking to yourself, well, we're all the way up in Alameda. The border is about what, 700 miles south of us? Actually, the Border Patrol does have jurisdiction within 100 miles of the continental U.S.'s border, including shoreline. So, being in the Bay Area, we're pretty close to the water there, so that does put us under the jurisdiction of the Border Patrol in some cases. So don't be surprised if you see them as well. Now, one question that we've gotten from members and from callers is, if ICE shows up, do I have to let them into the private areas of my business? So if I have areas that are for employees only or areas that are locked away, do I have to let them in? And the answer to that is, well, it depends. It depends on what kind of documentation they show up with. And that's why it's important for you as business owners to know what your warrants are, know your warrants and what they mean. So the first one that they could show up with is a judicial search warrant. This is signed by a federal judge or magistrate, federal court document, and it allows agents to either enter private areas or seize documents. This is a court order. This basically is their golden ticket to go in and do what they need to do within the confines of that search warrant. There's also judicial arrest warrants, which is basically an arrest order granted by a federal judge or magistrate that allows them to detain somebody. However, this does not necessarily grant them area access into private areas. And finally, you have the administrative warrant. And these are the ones that are issued directly by ICE or the Department of Homeland Security. Easy to identify because on the bottom they'll say they're either Form I-200 or I-205. The thing to keep in mind about those administrative warrants is, they could be called a warrant, but they're basically worth about as much as the paper they're printed on when it comes to giving them access to the private areas of your business. It does not grant any access to private areas. All an administrative warrant really is marching orders, if you will, for the immigration agents. Lets them know what they're supposed to do, who they're supposed to go look for, but it doesn't open any doors for them. We have a bit.ly link for you too if you want to learn a little more. We recommend that you get familiar with the different documents just to know what you're looking for. And again, when you're dealing with a judicial warrant, If they present you with one, it doesn't necessarily mean you have to step aside right away. Take a look at it. What's in it? What are the specific scopes of it? Does it allow full access to every area of the business, or is it just for documents or just for a specific area? Is it signed and dated by a judge or magistrate, or is it just a blank one, right? It has to be signed in order for it to be valid. It should have the right name. It should have the right address on it. All of those things should be correct. If they are not, then you have protections against that. Again, administrative warrants, these are the ones that are issued by the immigration judge or DHS or whoever it is. Basically, these are documents issued by the USCIS or by ICE themselves. Are very limited. They're signed by an immigration officer, and it basically allows them to arrest non-citizens suspected of committing immigration violations. So if someone overstayed their visa, if someone has any other kind of expired document or a removal order, this allows ICE or the Border Patrol to detain them, but it doesn't necessarily allow them to enter your place of business into restricted areas to look for them. So again, become familiar with the different kinds of warrants. Go to that link, see what identifies each of them, and make sure that you know what it means for you and your business. Now, as I mentioned earlier, the Border Patrol does have access within 100 miles of border, including the shorelines. And the thing about the Border Patrol is, they have additional, I don't want to say rights, additional enforcement beyond what you would see from a regular law enforcement officer, right? So, a lot of us are familiar with the Fourth Amendment and knows that it protects us from arbitrary stops and searches, search and seizures, stop and frisk and all that stuff. That's not allowed to be done by general police officers or general law enforcement. However, the Border Patrol does have the ability to conduct those arbitrary searches. That's what I saw was the big dust up when the Supreme Court decided that, hey, profiling someone based on their ethnic background or their race could be a reason enough for them to be stopped and questioned, right? This is something that a normal, regular police officer or law enforcement would not do because they get themselves in trouble. However, Border Patrol is allowed to behave in that manner. So next question that comes up, and I'll present this one to you as well. You can just answer it in the chat if you'd like. Can I voluntarily allow ICE into private areas of my business? In other words, if ICE shows up at your door, they don't have a warrant, they don't have an administrative warrant, they just say, "Hey, we just want to come in and look around." Can can you can you grant them that permission? If you know you got nothing to hide, can you let them in? What do you think? Yes, no, or maybe? Or not sure? It's all right not to be sure because that's a tricky one, right? Again, someone shows up, they show you a badge, they're law enforcement, you figure, what's the harm in that, right? And I know that's a tough one. Might have stumped you on that one. That's okay. Let's go see what our answer is to this one, right? And this one's the important thing to keep in mind is California has spoken up on this. Actually, Assembly Bill 450, this a law that went into effect all the way back in 2018. And one of the things about AB 450 did was it prohibited employers from granting immigration agents voluntary access to private areas of the workplace. In other words, AB 450 said, you know what? If an agent shows up without a warrant, without any court order, allowing them access, you as an employer cannot just grant them access yourself. Obviously, this was a very controversial decision or very controversial law, and different groups said, well, no, you can't do that. You can't prevent employers from giving people access to their workplace. That's their decision, right? Kind of went back and forth, and that part of the law was tied up. It was put on hold. It wasn't enforced until very quietly earlier this year, the California Department of Justice gave some guidance on this, right? They gave some guidance and said that, California employers, they can't consent unless they're under duress. In other words, this part of the law that was tied up in court for so long, it stands, right? Both sides that were kind of tying it up, going back and forth in court, dropped their challenges to it. So now this part stands. So as an employer, you cannot provide voluntary consent to entry to private or non-public areas of labor unless they have a valid judicial search warrant to search the area. So keep that in mind. So you could be asking as an employer, what rights do I have during a workplace raid or visit? What can I do? I know I can deny them access to private areas. You just told me that under AB 450. What other rights do I have? Well, as an employer, you're not required to confirm if a person is working that day or identify them to the officers unless they have a valid judicial warrant. So if they show up with an administrative warrant and they ask you, is so and so working today? Is so and so, you can say, it's our policy not to share that information. I can't tell you. If they have a judicial warrant, that's a different story. That's a federal judge telling you that you have to tell them. But administrative warrant, you can take a look at it, you can read it, you can hand them their nice piece of paper back and say, sorry, I don't have to tell you, right? You can ask them for identifying information, badge numbers, names, business cards. Take notes during the information, whatever it is. Document it as long as you're not interfering, right? As long as you're not obstructing them. You can document the entire visit. That's the beauty of having cell phones handy, right? You can document anything at the click of a button. And finally, if they are searching your workplace, you may accompany the ICE agents throughout the workplace. Say, well, why would I want to do that? They have a search warrant. Why do I need to accompany them? Well, just to make sure that they don't accidentally go into areas that are not covered by the search warrant and see things that they're not supposed to see or weren't intended to see, right? So accompany them, document the search along the way. So we talk about your rights as employers. How about your rights as employees? What rights do employees have during a workplace raid? And, our employees, whether they're U.S. citizens, whether they're, permanent residents, whether they're undocumented immigrants, whatever they are protected by the Constitution. Specifically, the Fourth and Fifth Amendment would apply. In other words, immigration officers cannot search people or their belongings without probable cause, judicial warrant, or consent. This is where it gets tricky, though, when we talk about probable cause, because it has been argued and found that if someone tries to flee during a raid or ICE visit, that gives the agents probable cause to go after them and question them, right? Because they attempted to flee. So this is where educating your employees and giving them resources is so important. Having a plan in place so they remain calm, because an attempt to flee can escalate the situation. So let your employees know that, right? Let them know, hey, if you try to run away, they can and will go after you, and then they can question you and detain you. The other right, of course, Fifth Amendment, is the right to remain silent. Applies to everybody, not just citizens. It applies to anybody under the jurisdiction of the United States government, which means anybody in the U.S. So basically, employees don't have to respond. They can remain silent and request an attorney to speak for them. So again, very important for your employees to be aware of those rights. So what can you do to prepare? And this is where developing a plan comes in very, very handy. And we recommend that, everybody do it, right? We have plans for earthquake drills. We have plans for, fires. We have plans for, you know, Cal OSHA visits. So let's put a plan in place in case ICE or immigration enforcement comes to our business. How do we do that? Well, first thing you got to do is decide who's going to be the coordinator, who's going to be the spokesperson to you, the point of contact on behalf of the company with these agents should they arrive. And again, it might be, we might say, well, it's going to be the receptionist or the first line, or it's going to be the general manager. They're in charge, so they should do it. As a leadership team, sit down and have an honest discussion about it, right? Because not everybody's comfortable having that conversation or the confrontation with law enforcement. So again, make sure that you talk it out, make sure that, the right person is in place to do that. It could be somebody off site. It could be a lawyer. You could decide that you want your attorney speaking for you, and that comes with its own, set of coordination there. So, but in case you have that on-site coordinator, you're going to want them to gather some specific information if a visit takes place. What agency they're there from, or agencies if there's multiple, names, badge numbers, that sort of thing, right? And again, if you have an attorney or legal counsel that you want to be alerted and do the speaking for you, make sure you have that number handy, you have that procedure in place, and you have the paperwork in place to make sure that they're authorized to speak for you, right? And on top of that, who else needs to be notified in case of a visit? Because not everybody's going to be on site. Maybe your owners are off site. So do you want them to know? How do you notify the staff? How do you notify management, right? That sort of thing. In which way can you share that information so that, rumors and panic don't spread throughout your organization? Okay. Now the important thing is once you designate that coordinator, that person on site, this is where that link I shared earlier comes in handy, right? You want them to be trained on identifying the different types of warrants and what to look for. And that link does a really good job of showing you, what are the different parts of the warrants, where should they be signed, where should they be dated, et cetera, et cetera. What are your policies? You know, what areas are restricted, what areas are not. Train your receptionists too. If they're not the coordinator, but they're the first point of contact, what should they do? Who should they call right away? Where are you going to have the immigrations and customs enforcement agents wait? Where are you going to have ICE wait? Do you want just milling along the lobby, kind of looking around, see what they see? Or do you have an empty conference room where you could put them in out of the way, where they won't be very disruptive, right? Until you contact the right people. And this is where, having a drill, practicing what you're going to do, practicing how you're going to react comes in handy. Repetition leads to doing it right when the event happens, right? On top of preparing your people, you can also do some things to your workplace to prepare. This, have some engineering measures, if you will, right? If you have any restricted areas, clearly mark them. Employees only, private, no access, that sort of thing, whatever you need. So nobody accidentally wanders in there. So clearly mark any areas that are employee only, that are restricted, or whatever it is, right? Train all your employees, your managers, your leads, your foremen, whatever it is, on authorized access areas only. If you have, say, a warehouse with multiple entrances, right, and you have agents kind of wandering about, they come to one of the roll-up doors and they're talking to one of the foremen, ask if they could come in. You want that foreman to know that, hey, you know what? We don't allow any unauthorized access to any of these areas, and only the general manager can grant access to come in, or whatever it is. Again, give them the knowledge and the ability to enforce those policies. And finally, make sure your employees' emergency contacts are up to date. Maybe thinking to yourself, well, I know all my employees are not undocumented. I did a check, I did e-verify, I did everything. I know they're not undocumented. I mean, there's been news of people who are citizens that have been detained or arrested. So again, make sure those emergency contacts are up to date. And this is further enforced by the newest law signed by Governor Newsom this year, Senate Bill 294, which mandates that employers must provide the opportunity for employees to name an emergency contact if they are arrested or detained for any reason. Deadline to comply by this is March 30th, 2026, and you also have to provide your new hires the ability to do that. So most of us have emergency contacts for our employees. That's not a biggie. It's the end of the year. Come up with a new form, or maybe in addition to a form, say who should I contact, or who should my employer contact in case I am detained or arrested. Right? As employers, our responsibility if someone is detained at our workplace, or if they're off-site conducting work for us, performing job duties, and we know that they're detained, we must notify whoever they've designated. Failure to do so can have penalties, as you can see, up to 10,000 per employee for violations. On top of that, the Labor Commissioner is going to develop a Know Your Rights notice that should be distributed to all your employees by February 1st, 2026. I don't believe that notice is out yet, so if you don't sign up to our blog, do so now. We'll make sure to share it with you when it comes out. And also, make sure you give that notice to new hires going forward, right? And to all employees annually. It's not just enough to post it up on the wall. We have to give it to all our employees so they're aware of their rights. Now, on top of that, we want to make sure that all our documentation is in order. A lot of times when we think immigration ready, we think, Customs and Border Patrol and ICE just coming and storming the place and looking for different people and tackling anybody that runs away, right? That's not always the case. And a lot of times what an ICE visit may look like is they're there to look at your I-9s, they're there to look at your documents. So that's why it's so important to make sure that your staff is trained on the proper procedures on how to complete those I-9s, right? What information are we looking for? What should be filled out? What part does the employee fill out? What part do I fill out? What do I look for in those documents? And the USCIS does do a good job of giving us resources on this. They have a manual for employers. They have some resources there to check to see, what to look for in documents, what dates to look for, that sort of thing, as well as, they do webinars and they do other training. So if you have an employee, whether it's your HR person, whether it's your office manager, whether it's a receptionist or managers, whoever it is that handles I-9s for new hires, go to the USCIS website and take a look to see when those webinars are coming up, unless we're having one, and sign them up for it. Get information on that, right? But some pointers for you though is you always want to make sure when you are completing a 99 form that you are using the most recent version. And the most recent one is from January 20th of this year. Um, when the new form comes out, you don't have to go back and fill a new one out for all your existing employees. It's just you just use it for all your employees going forward. Whether it's a new hire, whether it's a rehire, whether it's re-verification, whatever it is, you use the newest form. Also recommend that you audit your I-9 forms on a regular basis. Could be maybe at least once a year, once every 6 months, whatever it means. It's different for each organization, but take a look at them. Don't just fill them up once and throw them in the binder and forget about them. And speaking of binders, we also recommend that you keep your I-9 separate from personnel files. A couple of reasons. One is if you do get a notice of inspection for your I-9s, they're easier to access, right? They're all sitting in the binder. You don't have to go through every single employee file to pull them out. The other thing is if they ask you for a specific one, you don't have to go and pull out the employee file and give it to them and share more information than you have to. Well, I always recommend, keep those I-9 separate. Whenever any government agency asks you for something specific, give them just that specific thing. Don't give them more than you need to. Don't open the door for other questions to be asked. Okay. Now, getting back to what your coordinator is going to do. So whether the ICE is there for an inspection to look at your I-9s or looking for a specific person, the thing to keep in mind is the coordinator needs to be able to remain calm. I know it's difficult to say. Again, you got tactical gear, you got masks, you got weapons, whatever it is. But, you know, you're going to stay calm because you know what your protections are, you know what the law is, you know what your policy is. So again, they show up, you got to stay calm, verify what they're there for. Do they have a warrant? Were they just driving by and decided to cheer up your day? Are they there with a notice of inspection to take a look at your I-9s? What is it? What are they there for? They're not just there for no reason. They're there for something. Okay? Take notes, badge numbers, what agencies are there? How many agents are there? Business cards, whatever it is. If you receive a warrant, ask for a copy of it. Don't just let them flash a warrant at you and, yep, here's my warrant. I can go in. Nope. Let me take a look at it. Let me make a copy of it. Let me make sure everything is okay. And again, we're not going to obstruct ICE agents physically, right? We're not going to block their movements. If they insist on going past you, you're going to politely state any objections. Don't put yourselves in harm's way. Document it. Hey, they failed to present a warrant. I asked them to stop. They failed to do so. And contact legal counsel as needed or immediately, especially if they are um, going beyond what they should be. If they are being abusive, if they are, trying to inspect everything without a warrant, contact legal counsel immediately. Again, we're going to be polite and respectful, but firm. We have protections, Constitution, laws, AB 450, et cetera, et cetera. So, if you have an agent that wants to go into a private area, a restricted area, you could tell them something as simple as this. Hey, I apologize, but it's company policy not to provide consent to enter non-public areas of our facility or to access our information or records without a valid warrant signed by a judge. That puts them on alert that you know your rights, you know what the law says. And in speaking with some of our legal partners, and a lot of their experience, a lot of their clients have said, showing that you know what your rights are and you know what you're looking for, a lot of times that's enough for those agents to take a pause and walk back out. So get information. It's the most powerful tool you can use. Okay. Let's go a little bit more in depth into what a notice of inspection looks like. So what is that? It's when ICE or immigration wants to take a look at your I-9s. And You figure, well, the I-9, that's a federal requirement, so it's under federal law, but as we know, we're in California, so there are some specific requirements under California law and specific protections for that. So first question we get is, does ICE give us notice prior to auditioning our company's auditing, sorry, our company's Form I-9? So they have to notify us ahead of time. Well, the answer is they do. You have to receive a written request or a written notice of inspection for ICE to inspect your I-9s. And this notice of inspection can be either mailed to you or presented to you in person. The important thing to keep in mind, though, is that you have 72 hours from the day you receive that inspection to provide those records. Now, on top of that, since we're in California, there are additional requirements too. If we receive a notice, we have to post it within 72 hours of receiving it in a language normally used to communicate with our employees for our employees to see. And if you're in the union environment, you have to give the union representative a copy of the notice as well. So if you have an agent that shows up and says, hey, I want to look at your I-9s, ask him for a written notice of inspection. This isn't a verbal thing. They have to present you with a written notice of inspection, a written form, administrative warrant, whatever it is, judicial warrant asking you for review of your I-9s. Now, once they review your I-9s after they give you a notice of inspection, oh, and before we say that, I did mention you have 72 hours to present those documents to ICE. Take the full 72 hours. If they give you a notice of inspection, don't just turn around, grab them off the shelf, and hand it to them. Say, if they hand you a notice, say, okay, come back in 72 hours and I'll give it to you, because that gives you time to review it. Make sure nothing's missing. Make sure nothing's out of line. Hopefully, you've been auditing them and catching all those things, but again, take that time. Give it an extra look. All right. So once they're inspected, if they find any deficiencies, they'll give you notice of that within 72 hours. And within 72 hours, you have to give notice of those deficiencies to the employees with the deficient documentation, along with a copy of the form relating to them and any other relevant information. Now you have to present this notice to the employee either in person or, if not possible, say you have remote employees or what have you, by mail or email, something that can show that you gave it to them. So if you're doing it by mail, we recommend, a registered mail or something where you get a proof of delivery. Email, obviously, you can get a delivery notice or whatever. So question comes up, and talk about I-9s. It's question is, I mean, am I really at risk of an I-9 notice? I mean, you're talking about it, but is that something that I should really be worried about? And I mean, what do you think? Should you be worried about it or not? Throw a poll on here, and the question for you is, before you answer that or not, when was the last time you checked your I-9s? You conducted an internal audit. Did you do it in the last year, in the past 3 years, or have you never done it? You just fill them out and put them in the binder and call it good. Give it about, now maybe 25, 30 seconds, see what everybody says. So, not many answers, but I mean, looks like the majority said they've never audited their I-9s, and that's natural, right? I mean, you fill it out the first time, you do it right. Why worry about it? Well, I mean, do we always get things right the first time? I've been known to invert some letters or numbers from time to time, or just kind of go through. So, I mean, you really should be taking a look at them. At least once a year is what we recommend. So, and everybody is at risk because, again, I mentioned, we've seen an escalation of action during Donald Trump's terms. During the first term, I mean, I-9's audits increase year after year because honestly, it's low-hanging fruit, right? We see a lot in the news about, immigration raids at, different big box stores. I won't name any, or side of the road, or, at court hearings or immigration hearings or what have you. But think about it. I-9 audits are really low-hanging fruit. It's easy to get a notice of inspection. You go, you can leaf through people's I-9, see who their employees are. Oh, let me take a look at this, employment authorization or the screen card. Ooh, something doesn't look right. Let's dig in deeper. It's easy work for them, right? They're not having to chase anybody, tackle anybody, do anything. So yeah, I mean, we are at risk as employers. And at its peak, there was 12,000 audits conducted per year. 12,000 I-9 audits. That was before COVID-19 hit and kind of put everything at a halt. And there's anticipation that that number could climb to 15,000 or more per year now, especially going forward, right? As more people learn their rights, as more people, show some resistance in public areas, I mean, ICE is probably going to shift its focus to, hey, we're getting some resistance picking up people off the street. Let's go back and just look at some I-9, see if we could, pick any people up there, right? So there is anticipation that, yeah, that number is going to keep climbing from 12,000, which was a peak during the first administration, to 15,000 or more. So it's important to make sure your I-9s are in order and conduct an internal audit. So how do we do that? Well, I mean, what we're looking for is simple errors, right? Those simple mistakes that can add up really quickly. So when you take a look at your I-9s at least once a year, gives you a chance to catch and correct those errors and show that you're acting in good faith. If an agent shows up, takes a look and says, well, this one was wrong, I saw you correct. It's like, well, yeah, we're constantly looking to see what's wrong and constantly reviewing things and making sure that we are compliant. And if anything happens, that shows the court that, hey, you know what? This employer was doing everything right. They did everything in their power to make sure that they were compliant. So, we may be a little more lenient. I'm not guaranteeing it'll happen, but there's a better chance of it occurring in those situations. So, how are you going to conduct your I-9 audit? Well, designate a person, either somebody internal, part of your organization, or bring somebody in from outside. CEA has done I-9 audits before, so maybe if you have a general counsel or an attorney that you work with, they could take a look at them for you too, right? First thing you're gonna do is take a look at your roster. Who are your current employees? What's their start date? Remember, I mean, I-9s were not required for anybody hired before 1986, I believe it was. So if you have employees that have been with you since before then, first of all, congratulations, that's a long run. But second, I mean, they may not need an I-9. So again, you're gonna take a look at all your active employees and anybody termed within the last 3 years because that's a retention requirement. Gonna hold on to any I-9s for anybody termed within the last 3 years as well. And again, make a checklist. What are we looking for? Everybody's name on the checklist. Was the form filled out correctly? Yes. Were the documents revised correctly or reviewed correctly? Yes. Was there copies if you keep copies? Yes. And of course, if you have any really old I-9s from former employees that haven't been with you for 10 years or what have you, start purging them. Don't hold on to anything that you do not need to. Okay? So how you know what's too old? Well, first of all, you have to have I-9s for all current employees. Again, unless they were hired before 1986, but I don't think there's many out there. Make sure they're in a safe, secure location with limited access. So only your HR person, maybe members of management can access them. There's no need for everybody in your organization to look at them, right? Put them in a binder or a location outside of personnel files in alphabetical order. And again, once employment ends, remember you have to hold on to the I-9 for either 3 years after date of hire or 1 year after date employment ended, whichever is later. So pay attention to that retention thing. Once you don't need to retain it anymore, purge it out. Get rid of it. You don't need the clutter. So what do you do if an I-9 is missing? You conduct your audit and it turns out you don't have an I-9 for this hire that that should have one and they've been there for 3 years or 5 years or what have you. What do you do? Well, if it's missing, it's missing. Things happen, right? You're going to go back and give the employee the most current, the newest version of Form I-9. So if you hired somebody 5 years ago, you don't go back and look for the form that was used 5 years ago. You give them the newest version. Complete it as soon as possible, but you're not going to backdate the form. You're not going to forge the date. You're going to put the date of completion on there and then add a memo, signed and dated, explaining why the date doesn't match your date of employment. Just a quick memo in the back, signed and dated by you saying, conducted an audit on December 2nd, 2025, found this missing, filled out a new form, and the employee presented their documents on December 3rd, 2025. Signed, date, and put it in the file. If you find any mistakes, you can't correct those on the form. You can, but again, we're not going to white out or cross out anything, right? Or redact it. I mean, we're not going to totally blank something out. You can line out incorrect info and enter the correct information right next to it. So you're going to, cross it out in a way that shows what the incorrect info was, initial it, and write the correct information next to it. And this can be things like dates, incorrect birthdays, incorrect, whatever it is, right? Again, you're only going to correct the area that corresponds to you. So in other words, if there's a correction that needs to be done in the employee section, that's up to the employee to correct, not you. So if they misspelled their birthday or sorry, misentered their birthday, misspelled their name, put in the wrong social, whatever it is, you need them to cross it, put the right one in, and initial it and date it. And then if it's something in the employer section, same thing, you're going to do it as the employer. Once you do that, write a memo explaining what the correction was, when the audit took place, and why the correction took place, and attach it to it. Okay? If you find the I-9 that's just so completely wrong, maybe you had a temp that was working with you that day that didn't know how to complete I-9s or whatever it is, and there's no salvaging it, you'd have to cross out the whole thing. Just use the newest form and attach it to the old one. Okay? That's valid as well. All right? Now, if there's a name change in one of your employees, you don't have to update to a new I-9 form or update the I-9 form, but it's recommended that you do, and you can use what's called Supplement B on the new I-9 form. Employees aren't required to show new documentation, so if they get married, divorced, whatever it is, not required to do so. But if they want to change their name and have that be part of the I-9, go ahead and attach that to the existing I-9. Remember, the I-9 is just to verify that the employee is eligible to work for you when you hired them, right? So the original I-9 still stands. That shows that they have permission. If they change their name afterwards or not, that's fine. Just attach that to the existing I-9. They attach the new one with the corrected name to the existing one. Now, when you rehire somebody, there are some cases where you need to complete a whole new I-9, or cases where you may not have to. And really the breaking point in that is the 3-year mark, right? If you hire somebody within 3 years of the time they left you, then you have options. You can either use your original form with the re-verification section, or you can complete Supplement B, or a whole new I-9 if you want to. Say just attach it to the old one if you would, but you can just a whole I-9. If it's after 3 years, after you complete the original form, then you have to complete a Form I-9. So that 3-year mark, that's going to decide whether you can just re-verify their old form or do a whole new one. Now, something to keep in mind too is we don't have to re-verify um, anything for U.S. citizens or non-citizen nationals. In other words, permanent residents, right? And what I mean by re-verify is that in some cases, some of our employees present employment authorization documents with an expiration date. And in those cases, anything with an expiration date, passports, passport cards, um, that sort of thing, that have some kind of expiration date on them, those we do not have, those we would have to re-verify. Things that you do not have to re-verify, even if they have an expiration date, a passport, right? If the passport was valid when they present it to a U.S. passport, you don't have to re-verify it. Uh, if they present you with an unexpired permanent resident or alien registration card, you don't have to re-verify that if it expires while they're employed with you, right? I mean, a driver's license, if it was valid when they present it to you, you don't have to re-verify it if it expires while they're employed. Things you do have to re-verify is an employment authorization document, an I-94 with a temporary I-551 stamp, an unexpired foreign passport with an I-551 stamp. Basically, that I-551 stamp is like a temporary authorization, if you will, with an expiration date. Those you have to keep an eye on. So sometimes you can put little tabs or something on your binders or put in a reminder in your calendar to let you know, hey, Eli's employment authorization expires on January 5th of 2026. So make sure to re-verify and make sure that, he's got a new one or what have you. Now, there is what is called a good faith defense. In other words, you know, you look to see, or the court looks to see, was the mistake done purposely or was it something that happened, right? So technical errors, maybe it was the wrong birth date or you flip-flopped the number or something. They're typically less if you found that the whole thing was completed in good faith, right? So that's again, listing an incorrect birthday or a typo or something like that. Substantive violations, that's those have steeper fines, and that's like if you fail to complete a 99 within 3 business days, if you don't sign the I-9 form at the time of completion, basically if you fail to follow the process, so to speak. So there's, honest mistakes versus failure to complete, that sort of thing. And those are both going to be maybe seen a little bit differently and penalized a little bit differently. So what happens if you get a notice of inspection, you submit your I-9 forms, what can I expect from that? Well, it could be a couple different things that happen, right? The notice of inspection results, that basically it's like a compliance letter that lets you know, hey, we took a look at it, everything looks fine. A warning notice or notice of suspect documents let you know that, documents presented by an employee or certain employees don't relate to them or are not valid. So it's possible that, you could be in trouble for that. So take a look at those, right? Notice of discrepancies. They weren't able to determine if the employee is eligible to work in the U.S., so you should provide the employee with a copy of the notice and give them the opportunity to straighten it out, right? If there's technical or procedural failures, they let you know, hey, these are some things that we found were wrong, and you have 10 days to correct the form. So we found missing dates, we found, missing birthdays, we found whatever it is, right? A warning notice, that means that they found substantive verification violations, um, but there's an expectation that you can comply for it, right? So it's a warning, lets you know, hey, this is wrong, but we believe that you can correct it. So, um, notice of intent to fine, that's kind of the worst news, right? That lets you know that, hey, we found some incorrect technical issues or procedural failures, or we believe that you're knowingly hiring people incorrectly and you continue to employ people that aren't eligible, so we are going to fine you. That basically lets you know, hey, we found some mistakes, we found some things you were doing wrong, we're going to penalize you for them. So if you receive a notice of intent to fine, it's very important you have 30 days to request a hearing from the day it's received before an administrative law judge at the office of the Chief Administrative Hearing Officer. So if you get a notice of intent to fine, that is a good time to contact legal counsel and get that process going and start trying to mitigate the harm. Now, on top of I-9, we have what's called E-Verify. That's a free web service. And some employers may say, well, with the I-9, with so many things that could go wrong, why doesn't the government have some kind of, electronic process that we could use? Well, they do. They have E-Verify. It's free. It's a web-based service, and it's actually been available in California since 1997, right? So it's out there. It's voluntary in most cases, unless you're working on a qualified federal contract, and it could be mandatory. And basically, it's a way for you to verify that the employee, the employee's employment authorization documents are valid and that they are authorized to work in the U.S. It's an electronic process, ties into the USCIS, Social Security, et cetera, to verify their eligibility. A thing to keep in mind, though, is if you start using E-Verify, you have to use it for all employees going forward. So if you're a federal contractor and you say, well, I'm just going to E-Verify my employees working on that project, that's not how it works. Once you start using E-Verify, you have to use it for all new hires going forward, whether they're on that project or working for your company in some other aspect. So keep that in mind. Now, again, it's voluntary except for federal contractors. And some of the requirements, the employee has to present a social security number, right? So even though we do see that area that says social security number on the I-9 form, that is voluntary. However, for E-Verify, that is requires a photo on the identity document. So you can't just present a temporary driver's license. It's got to be a driver's license with a photo ID, for example. And it shouldn't be used to re-verify any expired employment authorizations. So in other words, if you had a person that came through your organization using the I-9 process and employment authorization document, it expired, you're going to re-verify that using the I-9 process. You're not going to use E-Verify to go back and check everybody's employment authorizations just because you're curious or you have access, right? So more information for E-Verify can be found at their website, whether it's about signing up, how to use it, why to use it, et cetera, et cetera. Take a look at it. And that kind of brings us to the 1 hour mark. So I do have some additional resources with you. I apologize. I threw a lot of information at you. So, there are some additional things that you can use though. We have the Handbook for Employers under USCIS. That's M-274. We have a link here for it. If you're curious about E-Verify, you can go on their website. There's also a guide for employers on what to do if immigration comes to your workplace from the National Immigration Law Center you can check out. And the Immigration Legal Resource Center also has information on your rights as a California employer. Remember, learn your rights. That knowledge is what is going to protect you. If you want to give your employees some resources, we have some from the Office of the Attorney General. The California Civil Rights Department has some good information or resources for immigrants. The American Civil Liberties Union has information on employees, actually people's rights, if they're confronted by ICE. And also, many of you may have seen those little red cards that inform employees of what their rights are. The Immigration Legal Resource Center has free downloads for those if you want to download them and print them up. I would like to remind you too, if you have any questions, whether it's about this presentation or any other human resource topic, give us a call at the hotline, 888-202-5668. Monday through Friday from 8 to 5, except for holidays, because we're people too and we need some rest. So take a look, give us a call. If you're interested in membership, any kind of membership beyond what we have now, we do have different options, everything from monthly associate all the way up to ultimate with corresponding benefits. And as always, we do like to know what you thought about the presentation. Did you like it? Did you like the information? And what would you like to hear about in the future? What else would you like to know about? So if you have a moment, take a snapshot of this QR code, answer 5 short questions, as Anna says. Won't take you more than a minute or two, and let us know how we did or what you'd like to hear about. Now, for those of you that are with us for continuing education, I do have some training codes for you. For HRCI, we have 722929. And for SHRM, that's 25-HSVPQ. So that is it for me. I'll open it up to Anna, see if we have any questions on there, or Darlene, if there's anything you'd like to add. Because I'm kind of talked out.
Oh, thank you. Thank you for the presentation, and we look forward to having future presentations. Thank you so much.
Perfect. Yes. Thank you, Darlene, Javier, your entire team behind the scenes for all that you do for employers in Alameda County and beyond. I did drop a link, as Eli mentioned. The way that we better serve you is by hearing your feedback. And there's also a brief question on there where you can kind of vote for the types of trainings that you'd like to see in the future. So we really encourage you to take the minutes to either scan that QR code or click on the link in the chat. And that will help us to help you. So with that, I want to thank you, Eli, for sharing your time and expertise with us. Thank you again to Alameda County for sponsoring today. And thank you guys for joining us live. And we look forward to joining you all and supporting you in 2026 and beyond. Thank you all and enjoy the rest of your week. Cheers.